The dissenting judge from that decision that I was talking about, Jerry Smith, issued a truly wild 100+ page decision in which he accused the majority of essentially being in the pocket of George and Alex Soros. He mentioned George Soros 17 times. This is a sitting federal judge appointed by Ronald Reagan. He accused the majority of lying and of doing the bidding of the Democrat Party. He just had a broadside against the majority's decision that seems aimed at the Supreme Court's conservative justices to tell them that he thinks this ruling is illegitimate and they should block it before the 2026 election. And I think that gambit is more likely than not to work.
Let's move on and talk about yesterday's three-judge federal panel in El Paso that stayed the Republican legislative plan for gerrymandering Texas to provide up to 5 additional GOP House seats in the midterm election. Interestingly, it was a Trump nominee who wrote the opinion for the majority in that case. I know you were saying earlier that, these judges do Trump's bidding, but that has not been uniform. But certainly they've looked more kindly than have Democratic nominated judges. But what is the race-based argument that the plaintiffs made here? And do you think that this stay on the implementation of it is likely to hold?
So it's a really interesting decision, and it's a little complicated, but I'll break it down. What happened was Donald Trump wanted Texas to redraw its congressional districts to give, as you said, Republicans 5 more seats in the House of Representatives. The Texas legislature is controlled by Republicans, but they weren't super enthusiastic about this. They were like, it's going to be overtly partisan. It's going to stretch our margins kind of thin. It's not something that we really want to undertake. It'll look very bad. It could provoke backlash. And so the Trump administration then concocted a scheme to create a pretext for Texas to redraw these districts for reasons other than politics. And the pretext turned out to be race. And what happened was the Justice Department sent a letter to Texas claiming that its current map had too much race to pass constitutional muster. It took race too much into account. Specifically, the Justice Department said that it had too many districts that put together Hispanic and Black communities in one district and did so on purpose. And the claim was that's unconstitutional. You packed these Black and Hispanic communities together because of their race. You have to draw a new map to unpack those districts, or we may file a federal lawsuit against you. The United States of America will come thundering down with the federal suit. 2 days later, the governor sort of assented. He said, okay, the Justice Department says we have to redraw these maps, so we're going to redraw these maps. And the legislature proceeded to redraw the maps in a way that the court said, and I think it's pretty indisputable, was laser focused on race. The court took a bunch of Hispanic communities out of these earlier districts and redistributed them in a way that was designed to maximize Republican advantage. That was especially easy because there was a big swing toward Trump among Hispanic communities in 2024. So Republicans said, we're going to create some districts that have more Hispanics who are going to go for Trump. And then we're going to redistribute these Black voters throughout other districts that are deep red so that Black voters won't be able to elect Democrats even if they want to. And then they left the white districts alone. They were like, the white districts are fine. We're not going to touch them. We're just going to sort these Black and Hispanic voters as we see fit to create more districts for ourselves. That is sort of the one thing that the Supreme Court has said that state legislatures simply can't do. The Supreme Court has really gutted a lot of the Voting Rights Act. It's poised to dismantle what remains of it very soon. But the Supreme Court has been pretty consistent in saying that under the 14th and 15th Amendments, under the principle of equal protection, states cannot target voters on the basis of race and then discriminate against them because of their race in drawing electoral districts.
So what would the threshold, sorry to interrupt, Mark, but just what would the threshold be? You said, would it be, you have to show in whatever successive appeals there are that keeping the white voters intact was the evidence of this being race-based? Because because Black and Latino voters are going to be dominantly Democratic. So that's a partisan gerrymandering. So is the evidence for what you're describing the fact that white voters were left alone in the districts?
So that was one piece of evidence. In cases like this, there's not usually like a single smoking gun. There's a series of facts that amount to the persuasive evidence. And so the court did cite the fact that these white districts were mostly left alone. But the court also sort of just pointed to the fact that the Justice Department told the Texas legislature to redraw these maps on the basis of race, which was not, in fact, legally required. I mean, the premise that you couldn't combine Black and Hispanic communities in the same district, it was totally made up. It was totally wrong. Like, even the Texas Attorney General's office recognized this. The court said it was flat out wrong. I think as a matter of law, that's just correct. And so the sort of through line here is that the Justice Department told the legislature, redraw these in a way that redistributes the Black and Hispanic voters. So usually we are in a situation where it's the reverse, right? Where legislatures are secretly looking at race, but they claim that they're only looking at partisanship because the Supreme Court allows for partisan gerrymanders. Here we have the rare case of a legislature essentially admitting we were using race because that's what we thought we had to do, and that is unconstitutional.
Hi, I'm Pat Morrison, one of the hosts of America at a Crossroads. If you like this video, don't just watch. Head over to our website where you can subscribe for early access to new programs, see our upcoming schedules, and connect directly with our guests in our weekly live streams. Thank you for watching.
So, Mark, if this stay holds through the appellate process and Texas's GOP favoring gerrymander doesn't happen, is California's Proposition 50 a totally separate issue? And could it withstand legal challenges at the same time that Texas's doesn't, and Democrats come up with a big net win?
So it's possible. The Justice Department has challenged the new Texas map as a racial gerrymander, but that's going to be a very steep uphill climb in court for a couple reasons. One is that this was a map that was not just passed by the legislature, but then supported by a supermajority of California voters. And
let me just say, you said, I think, Texas accidentally, but you meant California. Just wanted to clarify.
California's map has been challenged by the Justice Department as a racial gerrymander. And that's going to be an uphill climb because, again, Proposition 50, the enactment of this map, was approved by California voters. And the courts are very, very hesitant to impute racist motives to an entire state's electorate that passes a law through a proposition. It's very different when, a bunch of legislators in a back room just ram through a racist map, as opposed to legislatures proposing a map and then allowing the people to vote on them. And so I think it's pretty unlikely that a court's going to say that California's map is a racial gerrymander and that every person who voted to approve it harbored racism deep in their hearts and that it therefore has to be struck down. So I think that California's map is very likely to survive. But, the reality is I think it's pretty unlikely that the Supreme Court upholds this judgment against the Texas map. Part of that is that the Supreme Court is just super hostile to voting rights. The Supreme Court, as I just said, has done a lot to dismantle protections for democracy and access to the ballot already. The Supreme Court has repeatedly blocked decisions that attempt to make it easier to vote before an election or create fairer districts and better representation. And just today, the dissenting judge from that decision that I was talking about, Jerry Smith, issued a truly wild 100+ page decision in which he accused the majority of essentially being in the pocket of George and Alex Soros. He mentioned George Soros 17 times. This is a sitting federal judge appointed by Ronald Reagan. He accused the majority of lying and of doing the bidding of the Democrat Party. He just had a broadside against the majority's decision that seems aimed at the Supreme Court's conservative justices to tell them that he thinks this ruling is illegitimate and they should block it before the 2026 election. And I think that gambit is more likely than not to work.
So I wonder, you have states like California that have done just about everything they could to accommodate voting. Votes are counted even if they're received after the polls close on election day, as long as they're postmarked before the polls close on election day.
Which there will be a
Everybody
Supreme
gets-
Court case about this.
But
yesterday,
I was
by the
gonna,
way.
yeah, I was gonna get to that. So, and everybody gets a vote by mail ballot in California. That's the default, is opt-in. So, or opt-in. I always get those back. Everybody gets one.
Everybody,
So my
yep, same in
question,
DC.
yeah. So my question is, if the justices tend to be favorable towards states kind of, setting their policies, and if they want more restrictive ones, we let them do it. Does that mean that California, even if Trump tries to say, no, you can't accept ballots after the polls close, you can't do universal vote by mail, whatever it is the high court likely to say, hey, states run the elections?
It would be nice if the court showed consistency in this area. I would say it has a kind of a checkered history on this subject matter. I agree that if the court is going to generally uphold restrictive voting laws and unfair maps, then it needs to at least defer to other states that are trying to do right by their voters and running elections fairly with integrity. But the court came one vote away from abolishing independent and bipartisan redistricting commissions about 10 years ago. The court came very, very close to throwing out thousands of mail ballots that arrived shortly after the election in Pennsylvania in the 2020 race. The court has not always deferred, and the Republican-appointed justices have not always deferred to states that want to make it easier to vote and easier for ballots to be counted. So I am somewhat worried about this case that you teed up that I mentioned, where the Supreme Court will decide whether states are allowed to count these ballots that are postmarked and mailed before or by election day, but that arrive shortly thereafter. To be clear, it's not just California and it's not just DC. More than half the states count late arriving ballots, including Texas and Mississippi. So it's not even just a red-blue thing, although they are more common in blue states. But the lower court here ruled that states are not allowed to count late arriving ballots. Its decision was really incoherent. There is no federal law that says states can't count these late arriving ballots. The way that the Constitution describes these sort of procedures is that states get the first say and Congress can come in and change the rules if it wants. Well, a bunch of states have said that they want to count late arriving ballots, and Congress hasn't said that they can't. So the presumption should be that the states get to do what they want. But again, the Supreme Court has not always deferred to the states when they want to expand access to voting. So it's one that I would advise cautious vigilance on.
Now, next week, we are off. There is no America at a Crossroads program in observance of Thanksgiving. 2 weeks from now, veteran diplomat and peace negotiator Aaron David Miller is with Mantle and Brand for an update on Israel and President Trump's plan for the Middle East.